Welcome to Inherently Distinctive.
Hello and welcome to Inherently Distinctive with attorney Mark Goodman. Mark's practice focuses on patent law, trademark law, copyright law, and business law related to innovation. I am your host, Kevin Rosenquist, and today's episode is From Idea to Invention, the step-by-step guide to securing a patent. Mark, welcome.
Oh, it's great to be here. This is a thrill. This is
thanks for joining me. I'm excited to talk all things patents with you, something that you know very well.
Oh, for sure.
Well, let's start at the beginning. Can you explain the basic steps involved in obtaining a patent from idea to approval?
First, we might even want to start with what actually is a patent, right? I'll start there, and then we'll figure out how to get it, right? So, patent is if we get it, it's granted by the United States government, and most other countries have their own patent systems as well. And it gives you the right. It's like an imaginary real estate, right? It gives you the right to kick anyone off of that land if they're walking on it, right? It has but specifically with a patent, it gives you the right to exclude others from making, selling, offering for sale, or importing whatever is covered by your patent claim, right? Now, what's covered by the patent claim? Well, that's where where a lot of the game is in the patent system, right? Because you can have a large piece of real estate or a small or different shapes, if you will, right? I often use this example with potential clients. Think about the claims on your patent application or patent, if you get it, are the legal description of what's covered and what's not covered. So imagine this, right? Imagine a claim, Kevin, that reads as follows: a table having a surface member and one or more attached leg members. Okay. Period. So if you think about that, that would be an extremely broad claim, because that would cover every single table you could possibly imagine to be worth billions of dollars.
Yeah, I wish I had that. That'd be great.
The entire table industry, right? Yeah. But there's always a push and pull here, because all the examiner would have to do to reject you is find any kind of reference to a table in the history of the universe prior to your filing date. That would be a rejection, right? Now imagine a claim that reads: a table having a trapezoidal shaped surface member and exactly 4 perpendicularly attached leg members disposed upon the corners of said trapezoidal shaped surface member, wherein said table is made of mahogany wood and said table is painted pink. Okay, so now that's not nearly as valuable of a patent, but that's much more realistic that we can get it through, right?
Right.
Because if there's never been a trapezoidal pink mahogany table with a cylindrical, maybe that's patentable, right? So that's the basics. You get a patent for 20 years from your filing date. There can be some adjustments to that would be beyond the scope of today. And then, the basic reason we have this whole patent system is to encourage people to invent new ideas and get products and services based on those inventions to the market, right? So there's what we call a quid pro quo between the government and the inventors, which is create this invention, right? Bring it to market. We're going to give you an exclusive right to it for a period of time. After that, it does become public domain. You can keep selling your product if you're in that business, but then other people can come in, and hopefully you've made your money in that period of time. Because the idea is that without the patent system, we'd have a very big problem. Because let's say you come up with a new invention, you might have to invest a ton of time, money, resources into developing that new technology. And when you get it to market, right, if other people could just copy you and they could sell it cheaper because they didn't have to invest all that money and time in developing this thing. And knowing that, you probably wouldn't ever go forward with a new product in the first place.
Right.
And so then our society would be deprived of all this awesome new stuff. So that's really the basics. Now, getting back to your original question, just on how do we get it? Well, we prepare and file an application with the United States Patent and Trademark Office. And it's, I won't sugarcoat this, it's a long and complicated, difficult, and expensive process. So to do this, you got to be serious about commercializing your invention.
Okay, so let's pretend I have an invention.
Sure.
Never going to happen, but we're going to pretend that I have an invention.
You'd be surprised, Kevin. Inventions.
I don't know that I would.
I never think they would do that, and then they're like, you know what? I came up with this.
Fair enough. I'm not going to say 0%, but it's low. So anyway, so let's say I have an invention and I want to get a patent for it. How do I, what are the types of patents and how do I determine which one applies to my invention?
Okay, so interesting. A few things. Most common, there's a few basic types of patents, right? The most common is what's called a utility patent, which is what most people think of when they're thinking about patenting. Utility patents cover basically just new inventions, any kind of combination of features, functions, elements, or steps that is novel, right? Could potentially be patentable. The other types of patents there's also what's called a design patent. I don't love this terminology, but it's the terminology we have because everybody considers their invention to be some sort of design, right?
Sure.
But a design patent is, to make this distinction, is the ornamental design of a product, right? So just imagine the kind of shape of a Corvette or the hourglass shape of a bottle of Coca-Cola. Right. So non-functional aspects of it are potentially the subject of a design patent. And then there's also, and this is very niche, I haven't even done these before in my career, you can get a patent to certain types of plants. Like if you're breeding or genetically engineering plants, there's a separate category for that as well. How do you know which one applies? Most of the time you're thinking about utility, but you may want to also look at design if that's a big part of what you're doing is the industrial design of a product. And those are easier to get and less expensive too. So I think that would answer it.
What criteria must be met to determine whether an invention is actually patentable?
The most significant one is it has to be novel, right? So when you file a patent application, they're going to do is search the offices and try to knock you out, right? Try to find some other and it doesn't have to be something that's patented or applied for, although that's kind of the most common art that they would cite. It could just be something that was on sale or in existence publicly prior to your filing date, or something that was published, even like say in an academic paper, something prior to your filing date could be prior art, right? But anything in that category, you're going to have show that yours is different from whatever else is in existence before, and it also has to be different in a non-obvious way. And this is an area where we end up getting into all kinds of arguments, of course, at the patent office on what's obvious, right? But it is going to be gray, but there are some principles. I mean, so going back to my other example, right? Remember when I had that table, right? And I said, well, the table is painted pink. Okay, let's say we just had that, right? We had our other stuff, but never in the history of the universe has there been a pink table, and you come up with a pink table. Wow, patent that. Well, this would be an obvious example of something that would be rejected as being obvious, right? Because the examiner's going to say, well, okay, maybe there's never been a pink table before, but you know what, Goodman, your client, I mean, this is obvious, right? Any carpenter would know that you can take any color paint, apply it to any kind of table, and it's going to change the color to that color. This is not really an invention, right?
Right.
Now, of course, when you start stepping beyond that, it becomes a matter of back and forth on whether or not this is obvious. And there can be, you have an appeal right and so forth if you disagree with the examiner's decision, and it's that type of system. Other requirements for patentability has to be useful, which ironically is actually the easiest thing for us to satisfy, because the patent office almost always kind of takes your word for it that this is useful, right? And it basically the patent system takes the position the market is going to ultimately determine whether it's useful. So really all we have to do is assert some sort of utility in the application, right? So we think it's going to be great for this, right? And when they're looking at novelty, they're really just looking, is your invention different from anything else we can find? Doesn't necessarily have to be better, because better can be in the eyes of the beholder, and better can be determined by the marketplace once we get out into the real world and try to sell this, right? They just want to make sure that you've invented something new. So it does have to be useful. And then the other one that you can run into is you have to enable the invention. This is a technical patent term and basically means you have to describe the invention in enough detail that someone with an ordinary skill in the field that your invention is could practice the invention. They could make it, use it with that description, right? It doesn't have to be a full like cookbook recipe level, right? But it can't just be like, here are some broad concepts, but how does it actually work, right? That can be a problem, especially in some more technical areas. Patent office might want some experimental results to show like there's something here, right? Just imagine this, if I write a patent application, well, I just invented something. It's a cure for cancer. Okay. Well, how does it work? Right?
Yeah.
That's not patentable
That's all
because
you got?
there's nothing there where someone can say, okay, I'm going to put this together, even if somebody had a lot of skill in that area, right? It's not specific enough and definite enough,
Too broad, yeah.
and not enabled as well. So, okay, so those are the requirements.
How long does this process typically take?
The process does take some time. So let's break it up into some different kind of parts of this, right? So let's say to get a patent application drafted, reviewed, filed, and to get to patent pending status, right? That we can usually do that in 3 to 6 weeks. And if we have to, we can go faster than that if there is a deadline or something like that, right? We can hustle and get things done fairly quickly. What takes a long time is then the patent office actually getting to look over that. So under the standard examination protocol, it's going to be patent pending for at least a year and a half, sometimes 2 years. I was just looking up this before the show because I knew this question was coming. Is like the average pendency is like 2.5 years before you get a patent, right? So a couple comments on this, right? One is that, well, that sucks, but at least once you file the application, you can refer to the product as patent pending, which is most of our audience, I think, will at least have heard that term.
Oh, many
Patent
times. Yeah.
pending just means that you filed an application for a patent. That patent, although it hasn't issued yet, has also not been abandoned yet, right? So it's still pending. You're still working with the office to try to get it and could get it, right? Patent applications always end in one of two ways. They either get abandoned or they get issued, right? Issued means we got the patent. That's what you typically want. Abandoned means it can happen in two ways. One, rarely, but there are sometimes reasons to do this. Sometimes you voluntarily abandon a patent application, right? But then more commonly, people just give up and the deadlines pass and then it becomes abandoned, right? So if it's not abandoned or issued, we call it patent pending. Now, if you're patent pending, you don't have the right to sue anybody for knocking off your invention, but you can send them a cease and desist letter on your attorney's letterhead that's going to say something like, hey, fellas, we see that you're knocking off our product. Please stop. And if you don't, and if we ultimately get our patent, which we think we will, we can come back and sue you, kick you out of this space, and our damages will relate all the way back to when we notified you. So you at least have that, and that, quite frankly, that's valuable, right?
Absolutely.
It's not nothing, because especially since a lot of business people really don't want to have to go through the court process of the patent litigation anyway. So
Definitely
it's
not.
good enough. Now, that said, to speed up the application, I think I'm going to bookmark this, Kevin, because I think that could be a full extra podcast on some of the ins and outs of that. But there are ways to do it. And I'll throw some of the easier ones out here, which are if you are, first of all, based on who the inventor is, right? If you're, and I always have to like kind of cringe when I ask my clients about this, but like if you're over age 65, you can file a petition to make special and you'll get a significant acceleration in that. We just had this, I couldn't believe it. We had an application filed earlier this year and we got our first action in like 2 months, which is like, for the patent office, bizarrely fast.
That's
and then
crazy.
We filed an office action response, a quick interview, and we got our patent in like, from the date of filing to the issuance, less than a year. So that was, just because my inventor was over 65.
It was older. Wow, that's crazy.
Drop dead, waiting for this, right? So as well, if the inventor's in poor health, you can accelerate. You can accelerate if you can show that the product's being infringed, right? Which I think that's important too, because at least, hey, somebody's just straight knocking you off. You can go to the patent office and say, hey, we can't sit here and wait 2 years, right, for this, and go based on that. There's also, depending on your technical area, right? So if your invention is going to help save the world from climate change, we get a faster application, right? And there's some other categories too, depending on the type of invention, just based on policy, right? We're trying to encourage more. All right.
How much does it typically cost?
The cost of patent applications, obviously it varies. So utility, and let me I'll back up at least how I work, right? Because every patent attorney and law firm has a different either fee structure or hourly rate or way that they're charging, right? What I do is nearly all of my intellectual property work, patent and trademark filings, is based on flat fees quoted up front, right? I think most clients appreciate that because then at least you know this is what it's going to be for this piece of it at least, right? And as opposed to just being on an hourly fee agreement where you just don't know what's going to happen, right? And it's not like I never do hourly fee agreements. Like, for instance, if you are in a situation where maybe, and this would be a happy development, where we're negotiating a potential license agreement on your patent application or patent, that'd be an hourly fee agreement because I don't know how many calls or emails, what is it going to take to do this? Whereas like for a patent filing or something, we know what it's going to take based on the technology that we're looking at. And I have a whole flat fee price list that, once you talk to me, meet with me, that we release. So, but typical costs, I mean, you're going to have, here are the different types of costs. You got to have a patent attorney to prepare and file the utility application. You have fees to the patent office. You're going to have some cost for patent quality drawings as well. And so for a simple invention, all of that adds up to like around, in that 9 to 10,000 range for a full utility US application, right? So, that's about what we're looking at.
That's not as bad as I thought it was going to be.
It can be higher. Now, I would quote higher if your invention had some heavier technical elements to it. If it was computer software, biotechnology, biochemistry, chemical engineering, something like that, where you really have to hit the books on the technical side of it, then I quote higher than that, but that's kind of for the simpler inventions.
Yeah, special situations on that. So let me ask you this. Obviously, you're biased, but are you required to have a patent attorney or can you do it yourself? And tell me why I shouldn't do it myself when I get my invention going.
Okay, a couple things. No, you're not required to have a patent attorney. You can file these things on your own. I think, so a couple of comments on this. It's hard. Like it's even hard for us. And I do this all the time, right? There's a lot you will get yourself tied up in all kinds of like stupid procedural nuts, let alone the actual substance of the application, right? For the most part, right? Now, I know that there are some folks out there, some outliers that are inventors and they sit and study the patent laws and they kind of almost become like armchair patent attorneys and they can kind of get something through. Fine, but that's not for most of us. Right.
Yeah.
I'm okay if people want to try that. But, if you really don't want to spend the money on it, but I just don't think that makes sense, especially if you're trying to launch some sort of new product. Well, you're going to have to spend all this time and just mental energy haggling with the patent office and their system, and we can do it really, really smoothly. So some other comments. This is an interesting one. Remember when we were talking about the claims too? And that's where you really need the skill of a patent attorney to help you the most. You could, because there's three basic parts of a patent application. You have a detailed description of the invention, right? I think if you're smart and you know your invention, you could probably do that, maybe, right? Just write it up, right? And then you have drawings. There's a lot of technical requirements of the drawings, but you could get that relatively inexpensively directly if you wanted to, or figure it out. But on the claims, that's where you're writing the legal description of what this patent application is going to cover, what it's not. And there's a lot of strategy there. Yeah. And sometimes there can be almost a false success because let's say back to our example, let's say you claim a really, really narrow, it's a table and it's trapezoidal and it's cylindrical legs and it's mahogany, it's pink and it's all of these things. And what if you didn't need to put all those elements in? So sometimes I see people have done it themselves. They've gotten a patent, but they could have gotten a broader patent through if they had understood the strategy more, right?
That makes sense.
There are even some patent attorneys, I'm not part of this camp totally, but some patent attorneys will say that if you file an application and you get it allowed on the first action, you probably gave up some territory that you should have had.
Almost too easy to get.
Right. Like, say, Kevin, let's say you're selling your house and I go up to you and I go, Kevin, your house, $1 million. And you go, yes. And I go, maybe you might have taken $500,000.
Yeah.
Right? Like
I would have.
So back and forth here, right? So in that case, so a lot of patent attorneys feel that way, that if you're not at least getting some of your claims rejected initially, right, then maybe you didn't ask for enough, and it's almost like a negotiation in that way.
Right. Yeah.
And that might be something people get tripped up on. So yeah, generally. Now, there is we can talk about another topic that just relates to all of this, which is a provisional patent application. Have you heard of that, Kevin?
I have not.
No. So, because again, a lot of our audience would have at least heard of this, I think. But a provisional patent application is a easier, quicker, cheaper way to get patent pending. And for that, I am much more understanding if people want to try it themselves, but we offer that at a significantly cheaper level than what we were talking about for a full application as well, right? So that can be a good option. And a provisional system is like, say you come up with an invention, you want to get patent pending and just see if you can get some traction, right? So, and you don't have to do this provisional program, but it's an option. So the thing about a provisional is you don't have to have any claims in there. All of the very strict kind of format requirements of a patent application do not apply. You're just trying to dump the content in there and hold it. So the idea with the provisionals, let's say, Kevin, we file a provisional application. Right now we're in mid-February 2025. Right now this is evergreen, right? But let's say March 1, 2025, we file a provisional application. So we will be patent pending until March 1, 2026. In that time frame, we've got to file a real application to keep the process going if we want to, but we're also out a lot less money if we decide not to, let's say.
Right.
So
that makes sense.
Valuable. And so that's the type of thing that, like, if you're just trying to bootstrap this up, can be valuable. Now, your overall costs go up because you're going to do the provisional and you're going to do a regular application later, but at least your upfront cost is much lower.
Yeah, and you get a little chance to test it out.
So
yeah, makes sense. All right, well, thanks for tuning in to Own Your Genius with attorney Mark Goodman. To connect with Mark, visit goodmanlawnevada.com. And please like and subscribe to our channel. We love having you be part of our community. Mark, so good having you here. Looking forward to talking with you some more.
Yeah, and since it's our first podcast, I'm wondering if I can just have a few comments about the podcast and why we're doing it and what that whole thing, right? What I've noticed, I've done a number of public speaking engagements for inventors associations and business groups and so forth. And I've just found that, like, for whatever reason, people have a lot of questions about the law and strategy regarding the law in these areas. And there's a kind of, I believe that it's a minority of folks, right? This podcast is unlikely to become the next Joe Rogan show, right? It's a minority of folks, but it's a strong enough minority of people that are really interested in learning about this. And I feel like I really like sharing my knowledge. I enjoy doing this, and it could be a really good win-win for everybody. And so that was kind of the vision why I wanted to do this. And, I think that, if you like it, tell all your buddies that are inventors or entrepreneurs about the show, and maybe we'll build this way. It was funny when you guys asked me what the audience would be, and my initial reaction was, well, initially 50-50 chance my mom watches this, right? And then but we're going to grow from there, right? And I think, throughout the entire country, there are people that want to know about these things. And also, we're going to have, maybe stay tuned for this, some ways where you can submit questions. If you want your question on the show, submit it to me. Right now, the one way would be go to my website, Google Mark Goodman or Goodman Law Center or goodmanlawnevada.com, and just my email's on there. You can email me. And I'm sure going forward, we'll have some slick, more convenient ways to do that. And I think that'd be fun.
Yeah, I think that'd be awesome. All right. Well, thanks again, everybody. And Mark, we'll see you next time. Thanks for being here.
Okay, this was awesome.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.